Your full name and surname, please.
Benjamin Friedemann Collins.
Do you have any objection to taking the oath?
No, I do not.
Do you consider the oath to be binding on your conscience?
I do.
Do you swear that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please raise your right hand, say so help you God.
So help me God.
Thank you, Majesty.
Thank you, my lord. My lord, I did reconsider yesterday and I can omit all other documents, my lord. So thank you for the indulgence yesterday. I'm going to not introduce any further documents, my lord. There, on the perusal, it became apparent that there was just repetition of what we have in any event before this honourable court. So I don't intend to introduce any more documents. And then secondly, my lord, after the court proceedings yesterday, the witness approached me and he asked me to place on record, which is correct, that he never applied, and he'll give the evidence. Essentially, and I'll get it from now, that he never applied for the first warrant of arrest for Mr. Loubser. It was a colleague of his. So I just want to rectify that. I believe it's important that it's not attributable to this witness, my lord. I'll ask him and then we can resolve it. Captain Collins, do you confirm that yesterday after the proceedings you approached me in court in front of my colleagues?
I did.
Right, and what was the purpose of that?
I just wanted to clarify that the original warrant that was discussed yesterday of 7 October, that warrant wasn't applied by myself. It was applied by one of my colleagues who assisted me during the investigation in certain aspects.
And you identified as a female Captain Oosthuizen, is that
That's correct, Captain Oosthuizen.
Thank you. You applied for the second warrant?
I did.
Thank you. And that's what you came to tell me yesterday, to place on record in the interest of justice, is that correct?
That is correct.
Thank you. As you've heard, I'm not going to be introducing any further documents, and I do believe that we don't have much more still to cover, but I'd like to refer you, Captain, please, to tab HI, which is your answering affidavit in the Constitutional Court. Do you have it before? Sorry, I keep seeing a file this. I thought it was the file. My apologies.
Okay.
Does your Lordship have HI? Captain, it's your answering affidavit that you'll confirm, and the date is important, Captain, that you signed on the 10th of June 2024, and you'll see that on page 43. Do you confirm that?
th of June 2024, yes.
Thank you. Now, I'd like you... Just a moment. Beg your pardon.
You are now referring to the date that we see on page 43
Yes,
of your affidavit, Captain Collins.
That's correct, my lord.
And it is indicated as 10 June 24.
That is correct.
Thank you. Now, you've dealt with this both in your examination in chief and previously under cross-examination. So I'm going to refer you to specific paragraphs, but please, if you need to add something to contextualize or clarify, please feel free to do so.
Will do so.
My starting point, Captain, would be under the heading the events of 22 and 23 September 2021 at paragraph 10 on page 4 of your affidavit. And to read it to you for confirmation. During the course of my investigations into the asbestos project, I received a statement and transcript of testimony Mr. Lott had given to the State Capture Commission of Inquiry, and also had access to a computer and email accounts. After examining this evidence, I located email correspondence indicating that Mr. Lotte, seemingly on behalf of someone senior to her in the office of the Premier of the Free State, had requested and received payments towards a bursary scheme orchestrated and managed by the Office of the Premier, and or payments for other education-related activities from a number of service providers to the Free State Province. That's what you said under oath, is that correct?
That is correct.
And you yourself never identified that senior person from the Office of the Premier in this paragraph 10. Do you agree with me?
I agree with you, yes, sir.
Any reason why you didn't expressly refer to Mr. Magashule there?
At that stage, no. I can't say a specific reason for that.
Then if you turn the page to paragraph 12, you say, and then read it, the investigating team had numerous questions for Mr. Lotte relating to these documents which had been evaluated. Given that we understood that Mr. Lotte had agreed to cooperate with the state, we requested to interview her more fully and in relation to the facts within her knowledge, while she was employed as the personal assistant of Mr. Elias Ace Magashule, Mr. Magashule, and regarding the emails she sent and received as these documents together with the payments received met the jurisdictional facts for the crime of corruption. Now in that affidavit you yourself say, and it's from lines 2 to 3, given that you understood that Mr. Lotte had agreed to cooperate with the state, do you see that?
I see that.
In those circumstances, why did you not make any arrangements with her to meet rather than sending the FBI to survey her and see where she is?
I can't have a direct answer for that. It will be basically first to establish the exact whereabouts. That is the reason we approached the FBI.
But you agree with me that that's inconsistent with what you say here, that you had an understanding that she had agreed to cooperate with the state?
Well, that is according to the correspondence between Advocate Denason and General Gerber.
Yes, and you had her email, and you could have sent her an email and say, please meet me at such and such place and time. Do you agree with me?
I could have, yes.
Thank you. Paragraph 13. At this stage, Mr. Lotte had not been cited as an accused in the asbestos project case because she had cooperated with law enforcement authorities. You there reinforce that you wanted to use her as a witness because of the extent of her cooperation at that stage. Do you agree with me?
Yes, the state wanted to use it, yes.
Yeah. And there's no mention there of the delay of 9 months between the time that you'd agreed to cooperate and the time that you actually arrived to interview her. Do you agree with me?
I do agree.
Thank you. There's an error in paragraph 15. It's obvious, so I make no issue of it. The dates you got there is 22 September 2021. As I understand, it ought to be. It is correct. I beg your pardon.
Yes, it is.
Sorry. Okay, if we can then turn in this affidavit. You're detailing how you waited outside, and if we go to 17, Mr. Lotte travelled alone using her own vehicle and followed the 2 vehicles who were travelling into the Sheraton Hotel. The hotel was situated in Baltimore, about a 15-minute drive away from Mr. Lotte's residence. A conference room had been organised for our use in the hotel by the FBI. So you had, in fact, what I want to put you is made arrangements with the FBI to facilitate the interview without having made those arrangements with her. Do you agree with me?
My
I
Lord,
agree.
with all due respect, we have addressed these issues at length yesterday already. We're repeating the same evidence that had also been addressed by the legal representative of accused number 17 yourself. We're not getting anywhere new with all due respect, my Lord. The state has to object at this stage.
Yes, as far as this last question is concerned.
Thank you, my
certainly.
Lord. Thank you,
My Lord, I'll move forward. I'm not going to argue. If you can then turn to paragraph 19. You say here, and this is on account of what arose from your testimony yesterday, in 19 you say, Ms. Charlotte attended the interview voluntarily and we informed her that she was to be a witness for the state and had questions for her. Now I want to put you, Captain, she didn't attend voluntarily. The FBI had compelled her to attend. Do you have any comment?
I wasn't present during the visit at her house, speaking to her, so I cannot.
You can't dispute it.
Well, I cannot dispute it now.
Thank you. Paragraph 21. Brigadier Gerber and I commenced our question of Mr. Lawton during the course thereof showed her various documents which she would have known about, most notably her emails. On the transcript, there's no reference to any documents being shown to her. Do you agree with me?
Yes, according to the transcripts, yes.
Thank you. Then at 25 you say, at no stage during the course of the day on 22 September 2021 did Ms. Charlotte ask for an attorney to be present. There would of course have been no need for her to do so as we were interviewing her with a view to taking a statement as a witness for the state in the criminal proceedings by then already instituted in relation to the Asbestos project. Your evidence, as I understood, was that you did offer her an attorney. Is that correct?
That was
sorry, not offer, you suggested to her
to speak to
obtain
someone.
an attorney. I want to
That's
get-
correct. But that was at the end when the interview was already over. We suggested it and gave her some advice. Yes.
A lot of this has been covered and I'm with my learned friends on it. The next point that I want to refer you to is at paragraph 44. You say, Ms. Charlotte's legal counsel had informed the Free State High Court on 20 January 2023 in open court during a pre-trial proceeding that Ms. Charlotte would voluntarily return to the country to face trial. By 3 May 2023, her attorney, Victor Nkwashu, advised the prosecutor, Advocate the Nation, that he had not received any instructions from Ms. Charlotte or her family pursuant to that undertaking made in January 2023 as to a voluntary return to South Africa. A copy of the email corresponding between recording the force is attached marked AA5. Now what I want to put to you, Captain, is here there is no mention made of the fact that she was actually arrested in the ensuing period. Do you agree with me?
Just repeat that quickly for me. Excuse me.
Here there is no mention made of the fact that she was arrested during that period.
Is that in paragraph
44,
44?
44, my lord.
No, this paragraph doesn't say it specifically, no.
Yeah. And that was crucial because, and I'll show you, we're going to deal with it in great detail when we get to the emails. That was the reason why there was this email correspondence between Mr. Nkwashu and Advocate the Nation inquiring as to why, once an undertaking was given for her to present herself, she was actually arrested. You're aware of those emails, you referred to them yourself.
Yes,
Do you
I
agree?
know about the correspondence, yes.
Right. Is there any reason that you can think of as to why you left out her arrest in this affidavit?
No, I can't give a specific reason, no.
Thank you. Paragraph 49. So after thorough investigation was conducted through which documentary evidence was obtained, there was sufficient evidence on the face of the documents obtained to charge Ms. Charlotte in relation to the role she played in the Asbestos project. Despite this, I suspect that Ms. Charlotte did not act of her own accord when she sent the email she did asking for payments from suppliers. So on the one hand, you've said there was enough to charge her, you had evidence against her. On the other hand, you concede here that you didn't suspect that she had done so of her own accord. Do you agree with me?
I do.
Do you see the contradiction in that?
I do.
Thank you. Then at 50, you say, given Ms. Charlotte's initial cooperation with the State Capture Commission of Inquiry, with the investigating team, she was accordingly not charged in relation to the Asbestos project. So you had evidence against her, you took a view she might not be involved, and then you thought because of her cooperation you're not going to charge her. Is that correct?
That is correct.
Cooperation at that stage being obviously on everything we've read thus far that should implicate Mr. Magashule. Do you agree with me?
I agree with you.
Thank you. We can move forward in the affidavit. to paragraph 62. It has been touched on. I just want to put it into context, and I'll be very brief on it. You say here under oath, on the contrary, it is in the public interest for accused persons, particularly when they are fugitives from justice located in a foreign jurisdiction, to be extradited to the country seeking to prosecute them. Such persons ought to face the criminal charges brought against them. This is even more so when fraud and corruption pertaining to millions of rands of public monies are at stake. It is not in the public interest for such persons to raise interlocutory and unsupported preliminary objections to an investigation and extradition process when the forums for raising such objections still exist and will be available to the accused in due course. So there are two issues arising, Captain. Firstly, it was always envisaged that this trial court would deal with those interlocutory applications and any objections to the charges. Do you agree with me?
Yes, I do.
Secondly, you under oath identified Ms. Charlotte as a fugitive from justice at a time when you hadn't even bothered to send her an email to her known email address. Do you agree with me?
Yes.
Thank you. Then paragraph 73 on page 20. You say, while it is correct that the investigation into the Asbestos project commenced after Mr. Dukwana gave his testimony before the State Capture Commission of Inquiry, it is denied that the charges were brought by the third respondent on the basis of the recommendations contained within the report. So what you're saying here is that independent of that report you decided to charge. Is that correct?
Can I just clarify which report are we talking about?
This is the State Capture Commission's report.
No. No, we did not.
74. The report was only published in 2022, whereas the criminal prosecution against the majority of the accused had been brought in 2020, already long before the relevant report was published and its recommendations made public. You still stand with your earlier answer?
Yes, I do.
76. Ms. Charlotte was at that stage a witness for the state. This was because of a cooperation with the statement made to the Commission of Inquiry into State Capture. Here you specifically say that she was regarded as a state witness on the basis of her cooperation and the statement that she made to the Commission of Inquiry. Do you agree with me?
Well, I would say the interviews held by the State Capture Commission.
The cooperation in those interviews, but you expressly referred to her statement.
Yes, I do.
Then if you'll turn to 86.6. Neither Brigadier Gerber nor I made any threats, admonished Ms. Charlotte, or intimidated her. It is correct, however, that we told Ms. Charlotte to think about the matter overnight, as a failure to cooperate may lead to us considering her to be a suspect.
Excuse me, can I just switch?
Yes, sorry.
No, which paragraph?
86.6
Well,
on page
excuse
23.
me. Sorry.
I'll read it again. I see you weren't on the page.
On the correct page.
86.6 says, neither Brigadier Gerber nor I made any threats, admonished Ms. Charlotte, or intimidated her. It is correct, however, that we told Ms. Charlotte to think about the matter overnight, as her failure to cooperate may lead to us considering her to be a suspect.
That is correct.
And you must concede, with respect, Captain, that if you tell somebody, cooperate, or I'm going to make you a suspect, there's some intimidation or threat in that.
I wouldn't call it a threat or intimidation. I would rather say it's advice given.
So the advice was, cooperate or you're going to be a suspect, but you don't see that there's some type of a threat in that.
Some people might see it like that.
86.9. On the second day of the interview, on the second day of the interview, it is correct that we informed Ms. Charlotte that her refusal to cooperate by answering the questions we posed to her would lead to her being considered a suspect and warned accordingly. There is nothing threatening encompassed in such a statement. The questions we asked of Ms. Charlotte were based on her own documents. There could not have been anything she honestly knew nothing of. You see again that you've already conceded that that some people would see that as a threat. Do you agree with me?
It depends on how you will speak to a person.
Yes.
Then that person will determine whether it's a threat or not. And our demeanor or mine isn't of such to threaten a person. That's all I can say about that.
You say your demeanor, that's your perception of your demeanor, but you've already conceded that other people see it different, may see it differently.
That is correct.
Thank you. If you then turn, Captain, to 106, it's on page 28. You say Mr. Loubser was studying in the United States of America at Bay Atlantic University in Washington, D.C. through a bursary awarded to her by the Free State provincial government in 2020.
That's correct.
So you are fully aware of her status and how she got to study in America. Do you agree with me?
I was, yes.
107, on or about 16 August 2022, Mr. Rala Konsani, Director General in the Office of the Premier of the Free State Provincial Government, gave notice to Mr. Loubser of the possible termination of her bursary on the grounds of a lack of cooperation with law enforcement in breach of her bursary agreement. While a copy of Mr. Loubser's bursary agreement is not in my possession, Mr. Rala Konsani alleges in his correspondence that she breached the terms thereof by failing to cooperate with the South African law enforcement authorities.
My Lord, if I may at this junction object again, we have gone through these emails already that have addressed this issue. Again, we're repeating ad nauseum with regards to this. This is taking us nowhere closer to the actual issue while we are here, which is the jurisdictional limitation. We are going beyond that, my Lord, with all due respect and repeating.
Can we leave this?
No, my Lord, this is directly relevant and it hasn't been dealt with fully. It needs to be dealt with because the documents have been handed to your Lordship. Those emails are there, and it is my intention to address it here and later on in greater detail, and I'll explain why, and I have no difficulty. The state is trying to protect themselves because they actually ruined her life by cancelling her academic career and ensuring that she was brought back to South Africa, as I will prove through the exchange of emails and notices, and this witness was directly involved in it, which has not been canvassed thus far in any examination whatsoever. It's been kept away from the court, and they're shielding the witness from this very important aspect which needs to be thrashed out before this honourable court at least.
What is your question to this witness? This paragraph is concerned?
That he played an instrumental role in the withdrawal of her bursary to the United States of America by engaging Mr. Rala Konsani, the Director General, in the Office of the Premier, and facilitating her return back to South Africa, terminating her studies, which are proved through the documents that they handed in, which have not thus far been addressed.
The first question, Captain.
My Lord.
You have seen paragraph 107.
Yes, I did, my Lord.
Now, the first question that is posed now is, were you involved in the cancellation of the bursary? It's a simple question. Yes or no?
No.
But I don't accept it, my Lord, and I'll explain through cross-examination why. If I may, my Lord, and it's a pertinent issue directly relevant to this matter. Because his denial now is false, and I'm going to prove it to your Lordship.
By way of email?
Cross-examination, my Lord, and
cross-examination.
yes, my Lord, and documentation.
My Lord, if I may again, at this junction, this still does not bring us back to the point of what we are here for in terms of jurisdiction. And I'll disagree with my learned colleague. This has been taken up. In fact, it was even put to the witness before that her life, his accused number 17's life had been ruined. But beyond this particular legal representative is not appearing on behalf of accused number 17. Should this have been ventilated before the court, it would have been done by her legal representative. My Lord, this takes us nowhere with regards to jurisdiction, which is where we are with regards to the trial and the trial, with all due respect, my Lord.
And my Lord, I can't account for the fact of who ought to or should have asked or answered the questions. That's not a basis to object. The purpose, my Lord, is to assist the court in coming to a decision as to whether this court does or doesn't have jurisdiction. I don't accept the captain's answer, and I can show through cross-examination why I don't. But over and above that, my Lord, it would be directly relevant, and my learned friend is shielding the captain and the state from their conduct in this regard, if regard is had to the facts that I hope to elicit through cross-examination, my Lord, which will not be long.
This whole issue of bursary and the cancellation of the bursary and everything about, what has that got to do with the lawfulness or unlawfulness of her extradition, of number 17's extradition to South Africa?
My Lord, it's directly relevant to it, and I'll explain why. It's very easy. According to us, my Lord, Ms. Chaloto was studying in America. That's what she went there for. And if you trace her history as per her statement and everything, she's explained that she worked in various positions. She became the PA. She saw other people getting bursaries. She had always wanted to study further. She then worked there, saw how the system works, and then she herself applied for a bursary and received one to the United States of America. When the state, when the investigating authorities went to see her in America, they knew that was her status. We believe through the documentation, my Lord, that they had her arrested when they were working with the FBI on the basis of her bursary having been terminated and the student visa. So that's the first step, which is directly relevant with respect, my Lord. Secondly, we believe that thereafter she was given ultimatums. Either you cooperate with the police or we're going to terminate your bursary. That cooperation meant to implicate Mr. Makashula from the Premier's newer office, from the people that had replaced him. And thereafter, my Lord, when she didn't cooperate to the extent of implicating Mr. Makashula, they actually did terminate, even though she had explained herself and said how she'd worked so hard as per the documentation that's here to in fact cooperate and work there so that her bursary would not be terminated, which in fact we say the blame for which lies at the doors of these investigating officers. It's directly relevant, my Lord. My Lord, there is no basis to prevent me from cross-examining because it's something that should have been aired or questioned by somebody else. That's not a basis. If it's relevant, this court ought to receive the cross-examination on it. My learned friend knows that. We all know that as seasoned practitioners, and it's directly relevant with respect, my Lord. And it's the umpteenth time now that I've explained the relevance in front of the witness, and I don't have a difficulty because I'm not here to just catch him out. The facts speak for themselves as I'll show this honourable court.
Yes, well, the witness has now already said that he had no involvement in the cancellation.
And I've explained that I don't accept that, my Lord. May I have an indulgence on that aspect, my Lord?
So put it to him why you don't accept.
Yes, my Lord. I shall do so. Right. Captain, you testified previously that you had spoken to Mr. Ralakonsani on numerous occasions. Do you agree with me?
I do.
Right. You attended meetings with him and you refer to what he had done in relation to the bursary. Do you agree?
I do.
Right. I had intended doing this later, but I'm going to show you now. If we look at the AA documents in this tab, you secured those documents from Mr. Ralakonsani. Do you agree with me? They're at the end of this tab. I'll show you AA7 through to AA10. Do you agree with me, sir?
I do.
Right. The only way that you could have done that is if you spoke to him and said, listen, this lady is not cooperating, cancel her bursary. Do you agree with me?
Can I explain?
Please, that's what I've been asking you to do.
I wanted to explain.
Right.
Thank you, my Lord. The direct decision for cancelling the bursary is not my decision. We did report the circumstances to Mr. Ralakonsani and what is our intention forward. The question that he decided to cancel wasn't our decision. We laid him the facts in front of him and he made the decision on his own.
You played an instrumental role in the decision. Do you agree with me? We can save a lot of time.
Yeah, no, we reported.
You reported and you followed up. You didn't just report and leave, because we can see from the flow of correspondence, you are kept abreast of every stage of the development in that regard. Do you agree?
I agree.
Right. So whether you took the decision or not, you had influence over him in relation to the termination of her bursary. Do you agree with me?
The final decision would have been his, yes.
You haven't answered the question, Captain, and I'm not going to let you escape this one.
Okay, no, sure.
You played an influential role in that regard. Do you agree?
I cannot say yes or no.
Well, I'll unpack it for you. Had you not reported it, you'd still have been studying there. Do you agree?
Most probably, yes.
Thank you. So you reported it, which shows the influential role, and you followed it through the whole process to ensure that that was the effective result. Do you agree?
Yes.
Thank you. That should put that to rest. My Lord, having done that, I'm going to ask your Lordship in time and to save time to have regard to the following facts. And if you look at AA7, and I'm going to summarize it, that's a possible termination of bursary, and it's based on her failure to provide a cooperation to the law enforcement agencies in South Africa. Do you agree?
I see that, yes, and I agree.
16th of August 2022, and invited her to make representations, which she then did. And in her representation, she explained in AA8 just how hard she tried to cooperate and remain there in order to study. Do you agree?
I agree.
Thank you. AA9, 19th of September 2022, was a document that was secured by you for court purposes. Do you agree? You got it from Mr.
No.
Ralekonsani.
Yes, AA9.
Right. And then he says to her there in the middle, you are directed to report to my office within 10 days of the date of this letter to enable us to resolve this impasse with the South African law enforcement agencies. That had to have been with under your influence. Do you agree?
The request for her to return.
To resolve the impasse with the South African law enforcement agencies.
Yes, that I must say wasn't part of our decision.
Not your decision, but you were aware of it and you played a role.
No,
that's what you wanted to secure.
I was aware of the request he put to her. That I was aware of, yes.
Thank you. If we go one step further and look at AA10, the final document in this regard, she's told that the representations or submission does not provide substantial motivation to review or consider the decision to terminate her bursary with immediate effect. No further payments will be made to support her studies. The Office of the Premier, however, remains responsible to pay for her flight ticket to return to South Africa should she wish to do so. Do you agree?
I agree.
So that was a way to circumvent the whole extradition process by terminating her bursary and saying to her, right, just come back to South Africa freely and voluntarily, and then we'll have you as an accused. Is that correct?
Your Worship, State is going to have to object at this stage. This witness has clearly indicated that this was not by his causing, it was by Mr. Ralekonsani.
I think that question is unfair.
Thank you, my Lord.
He said he had no part in making the decision, and what followed the following.
My Lord, yes, we'll have to see. I'll leave it for argument, my Lord. I'm not going to argue through the witness. I have no issue with that, my Lord. Now, when there was an application for mutual legal assistance, the MLA, do you agree that it's both the police and the NDPP make application for MLA? It's a two-pronged approach. Do you agree?
I agree.
Right. And when that application for mutual legal assistance was made to the Americans, it focused on Mr. Ace Magashule. Do you agree?
Yeah, it's part of it, yes.
Yes. And the purpose that was expressed to be the purpose for the MLA was to interview Ms. Chilotta and requested permission for you and Brigadier Gerber to attend the interviews and take part in the questioning of the witness in order to obtain a statement or compile a statement for her. Do you agree with me?
I agree with you.
Now, in the normal course, and we know from practice in South Africa, the person's brought to court and asked questions by the local authorities. It's unusual for the foreign authorities to be able to question in a foreign jurisdiction. Do you agree with me?
I agree.
Thank you. Now, when you testified in chief, you said that what gave rise to this investigation and by yourself was an article in the press. Do you remember that?
Yes, we talked about a lot of articles. Are we talking about the one of Mr. Dukwana?
I've got no idea. You said there was a particular article, the newspaper article that caused you to investigate.
Well, okay, that's the beginning. Yes,
right,
that's the first article.
That article's not in the docket. Do you agree with me?
Yes.
Right. Now, in the docket, what you've got is there's a statement by Leona Kleinons from the DA. She's a member of the Free State Provincial Legislature. It's A19.
Yes.
And she claims that she was the person who spurred you on to investigate this matter, and in particular, Mr. Magashule and 2 other accused.
I do not agree with that, yes.
You don't agree with it, but she's gone. I don't want to hand you an article, but that's what she says. I agree with you. To me, it doesn't make much sense. But she claimed to have done so on the 26th of May 2020 in A19, which was handed to you on the 27th of May 2020. And then she followed up, you'll remember, I know it's been a long time, with a whole lot of annexures for her statement on the 28th of May 2020. You know of those documents, but you dispute that that's what caused you to investigate.
Yes, that's not the origin, yes.
Right. What I want to put to you is the actual origin and the reason why you investigated is evident from the C section of your docket, being the diary, in which you refer immediately in the first item to the Zondo Commission. Do you agree with me?
I would agree with you, yes.
Thank you. Now, we've touched on this, but I had said to you I'm going to go to the emails because they haven't been revealed to the Honourable Court, even though they're here. You testified in your evidence in chief that you said Advocate Horace, after discussions with Mr. Makashula, said she would return of her own accord in reference to Ms. Chiloto, referring to a pre-trial that you hadn't dated at that time. Do you remember?
Yes.
So firstly, I want to correct you and say that I did make that or give that undertaking to the court, but it was in the instructions of my attorney, Mr. Victor Kwashu. Do you have any comment?
I agree with you there.
Now, if your turn, and if the documents that the state put you but haven't been dealt with as yet, to tab F, and it's difficult to follow, and I'm going to ask you because I personally cannot work it out fully. If it works in a reverse order, but there seems to be a cut, and you'll possibly be able to explain because it's involved. If you'll turn to tab F, page 7. Does your lordship have it? Do you have it?
Yes, I do.
You'll see, and I'm trying to build up in time. So you'll see here that it's an email from Advocate the Nation to Mr. Nkwashu, or in which you and other parties were copied on the Monday, the 23rd of January. And it says, "Good afternoon, Victor," meaning Mr. Nkwashu. "I refer herein to the undertaking of past Friday. Please indicate when you're available for the appearance of your client. I am available from 13 February until the end of March. I would, however, want this matter to be finalized before the middle of March. Because of the cooperation of your client, the state does not intend opposing bail, except if there are drastic changes in the circumstances. The bail application can therefore be finalized by way of affidavit. To save time, you can send me such affidavit before the application. If it suits you, kind regards, your under nation." Now, what I want to put to you, Captain, and you cannot challenge this with respect, is this was an email on a Monday, just after midday, that referred to a pre-trial that had taken place in this Honourable Court before the Judge President Musi on Friday, the 20th of January 2023, at which you were present. Do you agree with me?
I agree.
Right. And that's where that undertaking that you had referred to was given.
Yes.
You agree? Right. Now you have to turn backwards, and I'll say it because it works in time. So if you're page back, Captain, to page 6. This is Mr. Nkwashu's response. It's about 2 weeks later, as I understand it.
Yes.
And it says there, Monday, February the 6th, 2023, from Mr. Nkwashu to, inter alia, yourself. You'll see your email there. And it's addressed to Advocate the Nation. And he says, "Dear Johan, reference is made to the email under reply as well as our telephone conversation of 28 January 2023. So it would appear, as from the emails, that they were in communication, not only as per the email of 23 January, but also telephonically on 28 January 2023. And Mr. Nkwashu says, "We would appreciate if we could get information about the purpose of Ms. Chilota's arrest shortly after the undertaking of her voluntary surrender, which was broadcasted live by different media houses in an open court on 20 January 2023 before Muzi JP. So you see the confirmation of the date and the pre-trial and the presiding officer there.
Yes.
And that there was this undertaking that was given, but that she was subsequently arrested, as you can see there.
I see that, yes.
And then he says there, the fact that the state and ourselves were in the middle of synchronizing our diaries, and Ms. Charlotte coincidentally gets arrested and detained ostensibly on an Interpol red notice, is making it difficult even for us to give answers to her and her frustrated family. Kindly confirm whether the arrest of Ms. Charlotte had anything to do with the extradition process which the state initiated and the charges associated therewith. I'll carry on, and I don't know if it's correct, you can guide me. It says here, we're looking forward to hearing from you about what are the charges that she's currently facing, what the process that is possibly being followed by your counterparts in the USA courts, yours faithfully. So this court doesn't know. Between the time, and it doesn't appear from your affidavits as I've shown you, between the time that the undertaking was given in the pre-trial
Yes.
by myself on the instructions of Mr. Nkwashu, and the time that the arrangements were made for her to return to South Africa, she was arrested in America. You agree?
I agree.
At that stage, we've established you were in communication with the FBI. Do you agree?
I agree.
We'll turn then to, returning backwards through this process, page 5. Sorry, I've skipped one. On the top of that page, I beg your pardon. You'll see at the top of page 6, Advocate the Nation responds to Nkwashu copying into Radio UN on the following day, being Tuesday, February the 7th, 2023 at 9:07 a.m. And he says, Miss M. Charlotte, recent arrest by the USA authorities. Victor, I unfortunately did not address the charges in my previous mail. I wish to confirm that your client will face the charges as it is outlined in the indictment of which you have a copy. Agreed?
I see.
Right.
Yes.
We then turn to page 5. And Mr. Nkwashu says, dear, this is now later that day at 2:12 p.m. You were copied in as well. He says, dear Johan, thanks for your emails. However, I inquire about the charges only refer to what Mr. Charlotte is possibly facing in the United States. We thought you might have information pertaining those. You see that?
I see.
Now we go further up that page, and you'll see it's another email that you were copied in, still on page 5. On the 8th of February, it's now the following day, Wednesday at 7:33 a.m., Advocate the Nation sends an email to Mr. Nkwashu copying into radio yourself, and he says, good morning, Victor. We requested extradition on the charges as per the indictment. As to the charges he's currently facing in the US after arrest, I have no idea. So he's saying, I've got no idea why she was arrested. We've only requested an extradition. You agree with that?
I agree with that.
So it appeared to be something unrelated to the extradition for which she was arrested by the American authorities. You agree?
It seems so, yes.
Right. If we turn to page 4, you'll see now at the bottom of the page, Mr. Nkwashu responds to Advocate the Nation copying you on the 8th of February at 12:47 p.m. He says, thank you, Johan. And then you turn to the top of the next page. I appreciate your prompt responses. Regards. So it was accepted at that stage that the arrest was for something else.
Yes.
Right. Then you'll see there's a gap. Still on page 4. In the middle, Advocate the Nation on the 16th of February 2023 at 11:17 sends an email to Mr. Nkwashu copying in into radio yourself, and he says, morning, Victor. Our telephonic conversation yesterday refers, so they're in telephonic communication as well. You agree?
I agree.
I've requested a report from the US outlining all that occurred regarding your client as you're in the dark, what precisely is going on. Is your client still prepared to come to SA on her own? If so, when? Thank you, Johan. So they're saying, we don't know why she was arrested. I'm going to get a report from the American authorities. But in the meantime, is she still coming back? You agree with
I agree with you.
Now, In response to that, you'll see an email on page 3, 16th of February at 3:44 p.m., in which you also inter alia copied. At the bottom of the page, good afternoon, Johan. We acknowledge receipt of your email as discussed telephonically. The writer is currently having a family bereavement and will endeavour to contact the family of Mr. Lot and obtain instructions and revert to you next week starting on 20 February 2023. Thank you for your email under reply. It's just explaining, and then you see Mr. Donation says thank you on the 17th. You agree with that?
I agree with that.
Right. Now, you'll see there, if you do, at the bottom of page 2, 23rd of February to Thursday at 4 p.m. from Mr. Nkwashu to Advocate Donation. At the bottom of page 2, it says, good afternoon, Johan. This is a follow-up to our communication herein below. We have been instructed that Mr. Lotte has been released from custody following her arrest and detention in January 2023. However, she has been ordered to appear before a court in Baltimore Court following the transfer of the matter by court from a detention facility in Atlanta in that country. We are further instructed that Mr. Lotte was scheduled to appear before a court in Baltimore on 17 February 2023 and is currently awaiting further communication from the authorities in that country in this regard. Accordingly, we are of the view that your approach to the American authorities would shed better light for all parties involved. Even Mr. Lotte would be in a much better position to make an informed decision regarding the questions in your email under reply. We await to hear from you, yours faithfully. So what Mr. Nkwashu is saying is, I can't get into, this is what I found out. She's been released, the matter's been transferred, but I don't know why she was arrested. You can find out. Do you agree with me?
I agree with you.
Oh. Then, on the 27th of February 2023 at 2:56 a.m., Mr. Donation sends an email where we see Maria Lerner from the U.S. Department of Justice, and it says as follows. Good morning, Maria. Please see the trailing emails. According to the last email from Mr. Nkwashu, the attorney of Mr. Lot in SA, she had to appear in a court in Baltimore on 17 February. Can you please inform us what occurred during the appearance and importantly what the current position is? As previously indicated, we will have no problem if Mr. Lotte comes to SA on her own. The question now is, would she be able to do so if she has to appear in court in the US? That's Mr. Donation's request to this lady, Maria Lerner, and he asks for a speedy response and he signs off. Do you agree with me?
I agree with you.
In the response to that, you'll see, reading the bottom of page 1 into page 2, it says as follows. It's from this Maria Lerner on the 27th of February at 3:45 p.m. To Mr. Donation, in which you were also copied. And the subject is Remus M. Choloto, recent arrest by the U.S. authorities. And at the top of page 2, we have the following. Good afternoon, Johannes. I just checked with my contact and was informed that all hearings for Ms. Choloto were cancelled when she was released, and she should have been apprised of that. I have no indication that the hearing in fact occurred. At this point, ICE will not intervene again unless they learn that she is no longer enrolled in school. Have been able to make any progress on the request for information we sent last month. Please let me know if you have any questions. Thanks very much, and best regards, Maria. You see that?
I see that.
You
yes.
see there just how significant her enrollment at school is. Do you agree with me?
I agree, yes.
In other words, and it's now apparent from the American authorities, that if you cancel her bursary, she has no right to remain in America, and she is compelled to return to South Africa. You agree?
No, not totally.
Well, please
If
explain
I
why
may
not.
explain. If I understand it, and as it happened, if I may say,
Please.
the bursary was cancelled, but the means of how she continued to pay her studies, that I do not know, but she kept on at the university. That was my understanding. So the mere fact of cancelling the bursary could have been a part, but it seems it wasn't a part for her not studying further at the BAU. That is my understanding.
So you're fully aware of all of this. We've established now.
All of the...
You've just told the court what you understood had happened, so you were aware of all of these developments.
Well, if we talk about the arrest of ICE, that I do not know. We speculated, but it wasn't on instruction of us. We were in the dark about that. And believe me, if I say till today, I'm still till today not sure. I can only speculate what happened there.
My point is, speculation and not speculation, you're fully aware of her status in America and how important her study visa was. Do you agree with me? It's clear from
that last part, Mr. Adams.
and how important her study visa was. Do you agree with me?
My Lord, we're making quite a jump from the bursary to the study visa. Perhaps if you can just close that.
I'll rephrase. Her bursary to study there was.
Okay.
Thank you for that.
Excuse me. The study visa expired. That I know. But it seems as if the fact that it expired didn't have an influence with the Americans for her to continue studying. That is what I understand.
But my point, Captain, is you were kept abreast of all those developments through these emails and other inquiries that you made with the American authorities. Do you agree?
No, I'm aware of this, yes.
Then we have an email from Advocate the Nation in the middle of page 1 on the 28th of February 2023, addressed to Mr. Nkwashu, in which you were copied. Do you agree with me?
Yes.
And it reads as follows. Good morning, Victor. Please see the email from the US. It appears that Mr. Lotter can stay in the US for the time being, although it is never certain what the authorities in the US might decide to do next, as the past few weeks have shown. In any event, the extradition process is still ongoing, and she should be brought before a court in the US as soon as we have clarified certain aspects. The question now is, does she want to go through another arrest and incarceration, or rather come back to SA as per the undertaking court? I suggest that the latter option would be best for all involved, especially your client. Please advise as soon as possible. Thank you, Johan the Nation.
I see.
You don't see that as a threat. It's advice.
It's an option.
That's advice, as you
Okay,
explained.
advice option, yes.
I'll put you, most people see that as a threat. Do you have any comment?
Some people might, some not.
And what's noticeable from this exchange of emails and consistent throughout this trial is when it suits the state for Mr. Nkwashu to represent Ms. Chiloto, there's no conflict, there's no issue. Do you agree with me? Here they're busy negotiating a return. It's no problem. There's no conflict of interest referred to. Do you agree with me?
Well, yes.
The last aspect that I want to touch on is a legal aspect, but the dates are important. So I'm not going to question you on the legal issues, that I'll leave for argument. I'm just going to get some dates that are extremely important as to the jurisdiction of this Honourable Court. And I'll make the point very, very clearly. So let me explain it, my Lord, so that there can be, and I'm very, very brief on this. There's a decision of the Supreme Court of Appeal, the very recent one, my Lord, that deals with extradition, that's directly relevant to this matter, and I'd be remiss if I didn't refer to it. It's a decision, my Lord, of Jonathan Richard Schultz versus the Minister of Justice and Correctional Services and others. It's marked reportable. I don't know whether it has been reported. I believe it has, my Lord. It's referred to as the neutral citation was Schultz versus Minister of Justice and Correctional Services and others. It was case 76/2023. Then in square brackets 2024, Zeta SCA 77, and in brackets 23 May 2024. And in essence, and the Captain, I'll explain the relevance. On the 23rd of May 2024, the Supreme Court of Appeal, a full bench of the Supreme Court of Appeal, handed down a very significant judgment in relation to extradition, saying, or dealing with who ought to apply for the extradition of accused persons to make it lawful. And it says, and my Lord, let me give your Lordship and my learned friends the reference, at paragraph 16, it says that this would raise important legal issues which will affect extradition requests in the future. So future from 23 May 2024. So firstly, Captain, what I want to put to you is, and we can go through it in great detail, the request for Mr. Lotta's extradition was done by the NPA. Do you agree with me? I can show you Ms. Advocate Somaru's affidavit. Tab C is Advocate the Nation's affidavit. They brought the application. Do you agree with me?
I agree with you.
Right. In particular, and you can look with pleasure, is tab C in that file, where Advocate the Nation explains the role that he plays in relation to the prosecution, and where he seeks her extradition and clarifies probable cause. And I'm not going to repeat the legal issues, but it's there. You agree with me that this is his affidavit that was used to secure her extradition? Do you agree with me?
Yes, I would say this affidavit is for clarify certain aspects that was
That's
raised by the
and
youth.
it says so. Yes, you're accurate.
Yes.
There were queries asked. We can summarize that, and thank you, Captain. And on 13 June 2022, it says in paragraph 2 on page 1 of 32, queries were raised. I'm not going to deal with them, and explains the role that he plays. And then, for completion's sakes, Captain, you'll see at the end, he gives a summary of the case against Mr. Lotta. Do you agree with me?
I see that, yes, and I agree.
I don't want to be accused of repeating things, but it's there. Now, if we look at this file that was given to us, Exhibit 9, and these are the important dates, if you would bear with me, please, Captain.
Sure.
Immediately after that, in the file we have tab D. And you are aware of these proceedings. I just want to record the dates. The first document in tab D is a 5-page document that refers to motion to proceed with extradition hearing. And you'll remember, now I just want to refresh your memory, there was an application by Mr. Lotta in America to postpone the proceedings because of envisaged litigation in South Africa. Do you remember that?
Yes, I remember
And
that.
then the judge said, the magistrate in the District of Maryland said, this must proceed on the next time. And that's an order that's given on the 21st of May 2024. You'll see the top of the page.
Yes.
The dates are given in the American format.
I see that, yes.
And if you turn to page 5, you'll see the order there is based on the foregoing. The government respectfully requests that the court dissolve its stay and calendar the parties for the extradition hearing at the court's next opportunity. So they're saying this matter must proceed on the next occasion, and this just happens to be the 21st of May 2024. You agree with that?
I agree with that.
If you'll turn then, please, Captain, to tab E. Here is the order of extradition that's signed by they call it the United States Magistrate Judge Aaron Aslin. And you'll see from the top of the pages, but there can be no doubt about it if you go to page 9, that this was an order that's dated the 7th of June 2024. Do you confirm that?
I can confirm, yes.
So that was after the Schultz decision of May 2024 by process of logic.
That's
But
correct.
if you would turn the page, Captain, you'll see there a document entitled Department of State, and that's where the final decision is made to extradite and signed off by the Deputy Secretary of State. Do you see that?
I see that, yes.
And that occurred on the 31st of July 2024. You'll see that date written out on the second page. Do you agree with me?
I confirm, yes.
Thank you, Captain. I have no further questions. My Lord, I have, just for convenience, unmarked copies of the Schultz judgment that I can hand to your Lordship and to my learned friends.
Yes, thank you.
Thank you, my Lord. Thank you, Captain. I have no further questions.
Thank you, Mr. Otis.
I think this, the decision of the Supreme Court of Appeal that has been handed up by Mr. Hollis, I prefer to mark it as an exhibit. Otherwise, these things are going to get lost.
Yes,
They're going to disappear in the days and the weeks to come.
Lord, we were at 13.8. I'm not sure if this can be conclusion or if rather.
I thought just let us make this
13, is it 13.9, my Lord?
13.9.
That's all we are. That's all I heard. Thank you, my Lord.
Thank you, my Lord. My Lord, if I may ask that if we take our tea adjournment now, that we then proceed after tea, that we just can have everything liaised, that we can run smoothly then and finalise in one shot.
Yes, yes. How much time do you need? Do you want an hour?
My Lord, I don't think an hour will even be necessary. If we take our normal tea time adjournment, half an hour. If it's in agreement with everyone, including the court personnel, if we then take our tea adjournment now perhaps, and then return at 11, if suitable.
I see heads nodding all over the place. Court will adjourn till 11 o'clock.
Thank you.
Thank you, Mr. McPherson.
Thank you, my lord. I will endeavour to be brief. Thank you, Captain. Perhaps if we can begin with the departure point of what has just been brought tonight with regards to my learned colleague and the dates specifically of the 23rd of October by which you had given Ms. Chilota as per the warning statement. Do you remember that? That she had an opportunity to provide your statement with, that was indicated in your warning statement that you took of her.
Was it 23
Of October?
23 September.
That it was taken on the 23rd of September and you had given her a period up until the 23rd of October.
That is correct.
You had also previously...
Sorry. I'm sorry for interrupting my colleague. I see my counsel for Q17 is not here.
Good morning, my lord. My lord, my name is Morakile, the initial is L. I am the attorney of record of the accused. It is my instruction that the counsel had given you an indication that she is requesting to be excused after lunchtime.
Yes, because her sister is
Indeed, my lord.
graduating in Pretoria, receiving a doctorate,
Indeed.
and she wants to be present.
Yes,
Yes,
my
and
lord.
I gave her permission to be away for a day or two for such purpose, and I take note that I was also informed that you would stand in. That
Indeed,
is
my
what
lord.
is going on, Mr.
Mr. President.
Yes, you were referring to the warning statement of 23rd September.
Indeed so, my lord, and that indicative in that it had been that up until the point of the 23rd of October that there was an opportunity for a statement to be given. And the answer thereupon was correct.
Yes.
It was also indicated that up until the 23rd of October, you had also not received any such statement despite the agreement.
That is correct.
Just to clarify, even subsequent to that, even subsequent to Mechilota being brought to South Africa, has any legal representative provided you with a statement based on the warning statement?
No.
And that was neither by the erstwhile legal representative nor the new legal representative.
That is correct.
Also, on a point of clarity with regards to the questions posed by my learned colleague, the question had been posed to you that there had been an article by a Mr. Dukwani, whereupon you had indicated that there were lots of articles that were referred to. Do you remember that?
I do.
Now, this article specifically of the one of Mr. Dukwani, do you recall that? Whether or not it was included in the docket?
I cannot recall. No, it wasn't. I can't recall whether it was included. No, I can't.
Despite whether you can recall it being included or not, can you recall that particular article?
Okay, yes.
The questioning had then moved on to the C section of the docket, which had began with the Zondo Commission. Do you recall that question?
I do.
The impression that was created by my learned colleague is that that is in fact what had prompted the investigations was the Commission report. Do you have a comment on that?
Our
The Commission
investigation-
report.
Indeed, so, my lord.
We didn't say
Excuse me.
report, we said the C-section was the inception.
No, the investigation started
The report.
long before that. If I say long before, as I mentioned previously, I started at the Serious Corruption Unit on the 1st of October 2019, and that was one of the first cases allocated to me.
Can we then clarify that further, and then what in fact prompted your investigations into the asbestos matter?
Well, it was the allegations or the news article itself which mentioned the awarding of the contract to the service providers. And if I recall correctly, in the news article it was also mentioned about the DA's court case and the finding of the AG. And that prompted for me to, and as per instruction by my commander, Brigadier Gerber, at that stage, to start investigating the matter, yes.
The counsel on behalf of Mayor Chilota, stood in for by the instructing attorney, had put it very definite to you that at all times Mayor Chilota was reachable either by the telephone or by her email address. Do you recall that?
I do.
And in fact, she had also further queried of you with regards to emails that proved something differently. Do you recall that?
May I ask just to clarify the emails that you're talking about?
That she had requested of you, that did you have anything that confirmed something different, other to the fact that Mayor Chilota was always available?
Yes, I can confirm that, yes.
And that we had then undertaken to the court that we would look for the same, being the state. Do you recall that?
I recall that, yes.
And that we did in fact hand them over to my learned colleague. However, she had put them to the side and not utilized them. You might not be aware of the same.
I am not aware of that, yes.
However, if I may hand to my learned colleagues with regards to the email as well as to yourself. My Lord, I'm handing the same to you. They are coming to my learned colleagues. Do you see this particular email?
I do.
You also see in particular that you are included in the email trail.
I see that, yes.
You were also aware of this email at the time.
I took note of it, yes.
If you will note, it's also with regards to the manner in which it's arranged, is arranged, my apologies, that the later date is first and it works down to the first date. You take the same into note.
That is correct.
Of importance, however, you'll note the email dated the 14th of March 2024 and the time being 5:43 p.m.
I see that, yes.
And this is a specific email from Maria Lerner, who had been sent to the lead prosecutor, as well as CCing yourself in, as well as certain other officials.
That's correct.
Captain, if I can ask you to please read this specific email into record.
Okay, this is, hi everyone, quick update. We have not yet located her. the U.S. Marshals learned of a possible second location for her and need to conduct surveillance to confirm. We have also not received the original copy of the supplement package. I don't know if your embassy has been able to track it down from FedEx. Thanks very much, Maria.
And you'll also notice that the heading is RES versus Magesi and 17 others.
That is correct.
If I may then refer you to page 2 of the email, with an email dated Monday, March 4, 2024, the time being 5:46 a.m. Do you see that email?
I do.
And this was from the lead prosecutor to Maria Lerner, with the subject heading also including State versus Magesi and 17 others.
That is correct.
If you look at the same email, if you look at the paragraph 2, starting at paragraphs 2.5 and 8, if you can just specifically read, as we can then indicate as to who in relation these emails are.
Okay. I said it was from Advocate Mason to Maria Lerner. Should I read from the paragraph? I shall.
Indeed, so please.
I shall appreciate it if you can give an indication of where you are in the process at this time. I, however, do not intend to disclose your process and timeline to the defense. We only need the info to prepare for the 15th of April. Your colleague indicated that Charlotta would at least be before court before the 15th, although not necessarily extradited. If that is still the case, we intend to request a postponement until Charlotta is finally extradited. The ratio being that it would be nonsensical to continue with the trial when one of the accused is before court in the U.S. awaiting extradition. Clearly, the defense intends to potentially use anything to ask for a remand and blame the prosecution, whether it is because of Charlotta or the late supplement of information. It is important to note that Magashule has a new political party, and the very important election in South Africa is on the 29th of May, right in the middle of the trial. It is our view that he will therefore try anything to have the trial postponed, but does not want to be the one requesting the postponement.
Thank you, Captain. If we can also then move to the next email. The header is on the first page, dated March 4, 2004 at 5:19 p.m. And this is from Maria Lerner. Do you see the same? The actual email itself continues on the second page. Are you aware of that?
I see that, yes.
If you're just able to read that particular email into record.
Correct. It's from Maria Lerner to Advocate Mason.
Yes.
Thanks, Johannes. This is helpful. We are planning to refer the matter to the prosecutor this week, bearing any problems. And the U.S. Marshals are currently trying to locate her so that they will know the location where the arrest is ready to be made. Indications are that she is still in Baltimore, but we need to confirm. The prosecutor will need to review the matter themselves before proceeding, but we will impress upon them the urgency. I hesitate to give you a timeline at this time, but things are moving along steadily. Best regards, Maria.
And at this point, you see this particular email said that we are trying to locate her. And in the first email that you had read into record is that we have not located her yet.
That is correct.
You identify the same.
I do.
What was your understanding of that?
My Lord, I just want to place on record that the witness is now under re-examination. This contradicts what he had said previously. So we would need to cross-examine him on the content of this, having never been given the opportunity or sight of these before.
My Lord, if I may, it does not contradict his previous stance. It was being that this is why we had to bring the same to light when he had indicated to the erstwhile counsel of Mayor Charlotta that there were emails that had indicated she had not always been accessible. And this stems, therefore, to that. It has been raised in the cross-examination, which is why we are now allowed to bring this to light.
Yes,
the same had also been provided to counsel, my Lord. She chose, after requesting it from us, she had not dealt with it.
My Lord, I have a note, as does my junior, of his testimony where he said He had a phone number, he had her email, and she was accessible at all stages. It was a question that was raised in cross-examination, answered that contradicts what we have here. There's no question about it.
Are you referring to what this witness says?
Yes, my lord.
My lord, with due respect, there's a vast difference to saying that somebody could perhaps be reachable via telephone or via email. This is confirming the locations. And that is, after all, whether one person is in fact traceable, and that is what this witness had also confirmed in terms of telephone and email. But here we have, as per his evidence, that he had confirmed that they still were seeking her, which this then confirms.
Ms. McPherson, let's hear from the witness himself. Captain, can you recall what you said earlier about her availability, about how she can be traced, how she can be approached? Can you remember having said anything in that vein?
Yes, my lord, I can. And as Advocate Pearson says, there's two differences. The one is the contact, but at one stage during my testimony, I did mention of a document that I can recall, but which I could not find at that stage. And the court gave me time to look for it. I said that even the FBI and all the U.S. Marshals could not get hold of her at her residence. And this was the email that I made reference of during that testimony. It was not for the fact that I couldn't phone her or send her an email. It was merely based on the testimony to say that when they were looking for her, they couldn't find her, and there was they had difficulty, if I can say it like that. And this is only just to confirm from the U.S. what Maria Lerner says from her side, that the U.S. Marshals also said they could not find her at the residence, to confirm where she's actually staying at that stage.
But you yourself, you had a telephone number, or not? And the email address?
Not to say a telephone number, but definitely an email address, yes.
So you could contact her by email if you wanted to?
I could have.
Thank you, my lord. If in any event that this may then be marked as Exhibit 15 now, I believe, my lord.
1310.
Are we going back to 1310? As it pleases the court, my lord, I believe that my learned colleague did reflect as 13.9. If we then continue on the 13 trend, my lord. Captain, what has also been questioned to you now quite a bit by my learned colleague is with regards to the arrest in the United States of Major Lotter. Do you remember that?
Just tell me which one are you talking about?
The actual arrest by the US officials of Major Lotter, the emails that were questioned to you just before my learned colleague stood down from his cross-examination.
The unknown reason for the arrest.
Indeed, sir.
Yes, I recall that.
And it is also evident from the exhibits handed up to the court that it was indicated from the prosecutor that he would endeavour to find out as to what was transpiring in the United States.
That is correct.
And it would appear that not only was it an unknown reason, but it would actually have been an unrelated reason to the actual extradition.
That is correct.
Captain, if I may hand another email to you. You will also see that you are in the email trail. If I may hand the necessary copies. My Lord, for record purposes, this would then be Exhibit 13.11. You see these particular emails, and you'll also note that you are included in the email trail.
I see that, yes.
If I may turn you to the email dated Thursday, February 16, 2023 at 6:21 p.m. If I may count pages for you, it is on page 1. It's on the 6th page from the top. If you see that this particular email is an email sent from Maria Lerner, and it was sent to the lead prosecutor as well as yourself being CC'd into the email trail. Do you see the same?
I do.
If you look specifically into the second paragraph, if you may read just that second paragraph into record.
From my understanding.
From my understanding, and up until where it ends off with information has been provided to me on this.
Thank you. I understand your frustration with the situation and will do my best to explain what happened. At your request and following the presentation to me via email of documents indicating that Mr. Lota's sponsor had withdrawn their support and she had overstayed her visa, I alerted immigration authorities of this information. My agency, DOJ, has no authority to order or authorize the immigration authorities, ICE, on how to conduct their matters, and indeed, ICE has their own attorneys who review such matters before acting upon them. Ms. Chilota was arrested for overstaying a visa, and since this matter was not a criminal one, I learned of its status only by reaching out to one of the ICE agents in the US and participated in that arrest. I learned earlier this week, however, that the immigration lawyer who reviewed her matter failed to consider one option that would permit her to remain in the country. That is, that she continued to be enrolled in school, even if she has no sponsor. And as a result, she was released. I delayed informing you to see if I could learn more, but no further relevant information has been provided to me on this.
There's also a further email, if we can turn to page...
My Lord, I need to point out one aspect, if I may. My learned friend objected earlier when I questioned this very issue, and I want to highlight the following that's coming out for the first time. This email that my learned friend is referred to, of 16 February 2023, and the relevant part that she refers to is as follows. An email to Advocate the Nation, and it says in the first line, at your request and following the presentation to me via email of documents indicating Mr. Lota's sponsor had withdrawn their support and she had overstayed her visa, I alerted immigration authorities of this information. So it leads directly back to what they had objected to earlier and proves exactly what I sought to prove through cross-examination, my Lord. And I need to record that because this is incorrect that it's handed in re-examination, but it's actually beneficial to the case that I seek to prove, my Lord, and I need to make that clear. Had I had this previously, it would have been the subject of the cross-examination. And there it is before your Lordship, black on white.
And the previous email.
Yes, and the previous email follows the same trend, my Lord, because the Lordship will note that the captain conceded yet again that he did have an email and she was traceable through an email at every time, but they never emailed her. So they both clearly, my Lord, ought to have been handed in chief, not at this stage.
Ms. McPherson, there is no real objection. So
no, indeed, so it was merely a noting.
You may proceed.
Thank you, my Lord. Captain, I'm going to also ask you to turn to the email on, as it was indicating, the third page of this bundle, dated Thursday, February 2, 2023 at 11:45 p.m. Do you see the same?
I do.
Could you also proceed to read paragraph 2 into record?
Yes. With respect to the interplay between deportation and extradition proceedings in the United States, they are entirely separate, and both are legal and valid routes to removing a person from the United States. Deportation has the advantage that a rule of speciality is not a barrier to what charges can be brought once the fugitive is removed, whereas in the extradition process, a U.S. magistrate judge can determine there is an insufficient basis on some or all of the charges you wish to bring, and could limit the charges on which the fugitive can be extradited. As long as the deportation order is finalized before the extradition inquiry begins, there is no need to continue with the extradition process, as the deportation order is a legal way to remove her from the country. However, if the deportation process is not completed when the extradition inquiry begins, then the deportation process is put on hold until the extradition inquiry is completed. Once both proceedings have been started, the extradition proceedings will take precedence.
And from that, it appears that there's a difference between the extradition, that the state was seeking the deportation with regards to the visa requirements.
That is correct.
If we may end this with regards to the email on the final page of the bundle, dated Thursday, February 16, 2023 at 3:59 a.m. This is an email from the prosecutor, the lead prosecutor. And if we look, you are also included in that email trail. Do you see the same?
I do.
If you may look, I wouldn't regard good morning as a paragraph, nor our telephonic conversation yesterday. So if you can read that first particular paragraph into record.
As mentioned by you, Ms. Charlotta has been released in the US. What I fail to understand is firstly, why me or my office was not informed of the arrest from the outset. Secondly, why we were not informed of the release of Ms. Charlotta and the reason therefore. And thirdly, why I have not received a report or statement regarding the history of the arrest, release, etc. I have requested feedback since the 31st of January 2023. On 9 February, after another query, Interpol replied that the matter will be discussed with you to get clarity. Nevertheless, I had to call you to get feedback only to hear for the first time that she had been released.
And from this, the very specific query was, I was not informed of the arrest from the onset, or what was happening, why the reason thereof of the actual arrest. Do you see that from the third line?
Yes, I do.
Were you aware prior to actually inquiring as to what the arrest was for?
No,
What the arrest was?
No, I was not.
And with regards to your investigations, can you say what the linkage was, despite what my learned colleague would like the court to believe, was between the ICE arrest, the immigration officials' arrest on that side, and the matter of the asbestos inquiry for which you were tasked, the asbestos scheme?
Well, my opinion is the two has anything to do one with each other, in the sense that the first arrest was based on the visa that expired. It was not done on the extradition application.
My Lord, if I may just approach my colleague. Thank you for the indulgence, my Lord. Just one last aspect. The very first email where the inquiry began was Wednesday, the 8th of February 2023 at 7:52. And this was directed directly to Interpol from the prosecutor. If you may read just that email into record.
Which one is that?
That is the very first email, my Lord, on page, the bottom, it's a bit deceptive, the bottom of the page says page 4, but it is page 1 of the bundles handed to the court of Exhibit 13.11. It indicates from Johannes M. De Mason, sent Wednesday 08 February 2023 at 07:52, my apologies. On the very first page, my Lord.
First page of the bundle.
The first page of the bundle, my Lord.
Wednesday, 8 February.
Wednesday 8 February 2023 at 07:52.
Yes.
Thank you, Captain. If you can just read that into record.
Good morning. I have not received any feedback on my previous mail. This means that we are still in the dark about a number of issues as outlined in my previous mail. While we are being bombarded by the attorneys of the accused and the media, this situation is totally unacceptable. I would have expected better cooperation from a specialist agency like Interpol. I expect an urgent response before we end that business tomorrow. Africa de Mesa.
So it is clear, as early as the 8th of February 2023, after it had been brought to the state's attention, inquiries were made as to what the purpose of the arrest was.
That is correct.
And if we look at the trend of the email, it was some time before an answer was given.
It was, yes.
And that we can see that had requested, as per the email that you had read, the previous email that you had read into record, the dates indicated of the 31st of January 2023, where there had also been a request made,
That is correct.
and yet it was not provided.
That is correct.
Thank you, my Lord. Nothing further.
Captain, it appears that you have come to the end of your giving evidence in this trial within a trial. So you may stand down and you are excused. I don't know whether you will be called again later during the proceedings, but for now you are excused.
Most probably. Thank you.
My Lord, may I ask the status of the emails that were handed in that were not referred to? Because my learned friend hasn't addressed that. I think that, as I said earlier, we hadn't seen them before, but there were only extracts of emails that were referred to. What is the status as far as they're concerned as to the balance of the emails and that were those parts that weren't referred to, as well as the emails that in their entirety were not referred to that were handed in now by the state? Because they seem to be not in the same order. And I just need clarity on that, because I think it will be important for the argument in this matter.
Well, will one not be in a position in the end to look at the dates and compare the dates and to put something together by that means? Is it necessary for the state to
My Lord, they've handed up emails that they haven't referred to, and if I can give your Lordship an example which clarifies issues. My learned friend referred, when she dealt with the second bundle, my Lord, she referred to an email of the 2nd of February 2023, and she jumped to the second paragraph. In the first paragraph it says as follows: Good afternoon, Johannes. I wish I'd been informed of the prior arrangements. I could have notified immigration officials to wait a little longer in the event you self-deported. I have sent inquiries to them asking for additional information on what happens now. If she is in fact willing to be deported instead of challenging the proceedings, I will let you know what I learn when I get an answer. I will note, however, that from your email it seems that you are taking your word that you had voluntarily bought a flight to South Africa. I recall you informed me that she has a flight risk to Nigeria, where her boyfriend is from, so I guess there was a danger that she would flee elsewhere. Now, the issue is that was not referred to. Can we accept that will be maybe utilized in argument later, because it hasn't been the subject of any examination in chief, cross-examination, or for that point re-examination.
I see what you mean, Mr. Otis. You say there's an email now before you.
Yes, my Lord.
And there was only specific reference to certain parts of that, and
yes,
you want to know whether that whole email can be used by whoever wants to use it.
As well, my Lord, as the emails that were not referred to that are in this bundle. There are emails here that were handed up, and I can give you, if you just look at the front page,
My Lord, perhaps I can just,
Yes.
to assist my learned colleague, in fact it's an email trail, as is evident from what's before court. State has no objection as it is handed in as an entire email trail. Should my learned colleague refer to any of those in his arguments, he is more than welcome. That would then cut this quite a bit, my Lord.
There you have it, Mr.
Thank you, my lord. Thank you.
Anything else you want?
My lord, I think it would have extended the cross-examination somewhat. but I'm
It's
satisfied with
refused.
that, my lord.
Thank you. Yes, Ms. McPherson, is the state going to call any more witnesses in this trial within the trial?
Indeed, so my Lord, we had already indicated that the next witness that would be called is the now General Gerber, my Lord. Unfortunately, as already indicated initially, that he was only available as from next week, that we had cautioned the court when we had begun with the leading of the trial within a trial, due to the fact that he was present in Bloemfontein and unable to attend to work with the National Commissioner.
So when can he be available to testify?
My Lord, from what I'm aware, that he is able to obtain a flight to Bloemfontein on Tuesday the 20th of May.
At this point in time, are there any other witnesses that the state will wish to present in this trial within a trial, or is it only Gerber?
My Lord, again, it's a difficult aspect to give a definitive answer on, as it is also dependent on what cross-examination is
Yes,
put.
I understand that, but I mean for now.
There is a possibility of one further witness being called, apart from Gerber.
Apart from Gerber.
Indeed so. However, that is an aspect that needs to be taken to deliberation. That particular witness is also not local, and therefore would not be able to attend now. We were unaware of as how long we would proceed with this particular witness.
Yes, well, you say that Gerber will be flying down to Bloemfontein
Indeed so, my Lord.
on Tuesday the 20th.
Indeed so, my Lord.
And I suppose we don't know for sure at what time you will land here and at what time you will be present here at court, and I can just imagine that you would like to consult with you
It would be beneficial, my Lord.
before you...
My Lord, if I
Well-
may hand over to my learned colleague, as he's been in contact with General Gerber himself.
If I could just add the following. He flies from Cape Town on Monday to Nelspruit, and from there to Oa Tambo and to Bloemfontein on Tuesday. He tried to reroute to come directly from Cape Town to Bloemfontein, but that presented problems. So that is the position as it stands now.
Am I correct in saying that it would appear that we will only be able to start hearing his evidence on the 21st?
As it is.
Is there any of the counsel or the accused who has an objection if we now stand this matter down until Tuesday, 21 May?
It's Wednesday, my lord, not Tuesday.
Sorry. You are indeed correct. It is Wednesday, Wednesday 21 May next week. Any objections? Well then, in the premises, I adjourn this matter to Wednesday 21 May 2025 at 9:30 in the morning. All the accused are warned to be present. The bail are extended accordingly. The court will adjourn.